Hi there, this is Val Heminger, and I've been a divorce lawyer for almost 25 years. I am the owner of Pathway Legal and one of its founders, along with my tremendous law firm family. You might be in a place where you have a separation agreement that was done like a long time ago. Maybe your kids were really, really little and now they're 10 and 12 years old and they're asking to spend more time with you. Maybe when you entered into your a court order, there was a court order and your income was a certain amount and now it's been drastically reduced. So you want to be able to look at revising your obligation or revising your entitlement depending on what side of the fence you're on. Particularly with the case with kids, in our experience, a final order is almost never always an absolute final order or final agreement. Sometimes they become teenagers, move in with the other parent, they leave home, they come back, they go to school, they come back, all that kind of stuff. So the thing is that we can't exactly have a ton of finality as much as we'd like to sometimes when it comes to parenting, but that's because kids, of course, are, people that move and change. Now, you can have final agreements as it relates to your spousal support obligation, for example, or a final order as it relates to that in, as spousal support in court. So at Pathway Legal, here are some of the cases that we've had where we went to court and we modified an agreement. Or sometimes what we did instead was we attended mediation to modify a previous court order, or mediation arbitration, which is amazing. One case we had, the child was 4 months old and a dad had not had an overnight ever with the child. And so at that time, we had entered into an order that had him having certain overnights. And then eventually it was like every Wednesday and then every second weekend, which was a huge amount for the dad to get at that time and really hard for the mom to accept because the child was so little. Well, now that child's 8 years old and really saying, hey, I want to spend more time with my dad. And of course, there's less and less reason, and we can't actually see any reason at all, why the current order for parenting time would stay in effect. The original order was by consent, so we could consent to a new one. Oh wait, but we don't have consent. So then we might make an application to court to deal with that. So that's one particular area where the parenting time has changed. We had another case where a dad and ex-spouse was applying to reduce his spousal support and child support obligation. In fact, what he did first, you try to ask the other parent or their lawyer to see if they can come up with an agreement. So in this particular case, when dad entered into the separation agreement, his income was $380,000 per annum. Then what happened, because his industry changed significantly, his income went down to $80,000 per annum. So because mom would not agree with us with changing the amount payable, he ultimately had to make an application to court, and then the judge made a decision. So here's the thing. At Pathway Legal, we always want to make sure we use court as our last resort. But sometimes when you don't get the other side to agree, from your perspective, you don't think they're being reasonable, that's when we go to court. In my experience, of the thousands of files we open up every year, there are only a few that actually ever go to a full Supreme Court trial. In another case, to give you an example of where we have had court orders revised, a case where the dad was very stressed, and this is something that happens quite a bit, very stressed during the separation. They get served with court documents and they stick their head in the sand. It's like that just happens sometimes. People aren't at their best when they're going through a separation. Because they ignored the court application and didn't show up at court, mom took the stand and gave evidence that indicated that dad made a certain amount of money that was way more than he actually made. Now, here's the thing. She's probably guessing, could have been guessing, because she's like, well, he makes this much per hour, he works this many days per week, that kind of thing, this many weeks per year, and maybe she had that wrong. But, and it's kind of lands at his feet too, because he was supposed to file a financial statement. If he didn't do that, then, orders can be made against him that are incorrect. So that happens. And in my experience, when that happens, the courts can be quite kind about revising the incorrect number if support is payable at too great a number. It also goes the other way. Let's say, for example, there was no proper financial disclosure, and then there was an order entered into, and then one of the parties, when there was disclosure, found out that the paying party had greatly underpaid or underestimated what their income was. Well, in that particular case, the court's going to likely bump it up to what that person should have been paying all along, probably creating an arrears situation. Finally, in another case we had, the parties had entered into a separation agreement. Pursuant to the terms of the separation agreement, the dad was to pay all of the Section 7 expenses. What's a Section 7 expense? Well, it's pursuant to Section 7 of the Federal Child Support Guidelines. And there's certain expenses that are over and above what we call the table support. The table support, or the guideline amount, what that is that's like, well, dad makes $120,000, he's got 2 kids, boop, there's your number. Okay, that's easy. But then sometimes there are extra expenses on top of that. So private school, braces, tutoring, that kind of thing. People often get very confused as to what a special expense actually is. For example, if someone is buying school books for the beginning of the school year, that's not necessarily a special expense, because when the paying parent is paying support, they are already, in essence, making a contribution. So what ends up happening a lot of the times is people just cannot decide or figure out what is appropriate for special expenses, what they should be. Sometimes an agreement will say they have to agree first, and the other parent doesn't agree at all. So what we need to do in that particular case is come up with a system, a way of ensuring the special expenses are paid, that they're agreed upon, that they're not unreasonably denied, that kind of thing. So we had that kind of case, and what we ended up doing was we resolved that by attending mediation arbitration. Powerful stuff. So you try to mediate the issue, meaning you have a mediator, one of the lawyers at Pathway Legal, the other side, and their lawyer. We sat around trying to come up with an agreement with the assistance of a mediator. But if we didn't come up with an agreement, which we did, that mediator had the authority going in, because we signed an agreement saying so, where they take off their mediation hat and put on their arbitration hat and say, okay, this is how it's going to be. So a very effective and cost-effective and stress-effective, because it's kind of all done, way of dealing with, that kind of a concern, that kind of a disagreement about special expenses. If you have a case and you want to, and you think that it's time to review that separation agreement or review that court order, you can contact us at Pathway Legal. Of course, every case is different, and we'd be happy to chat. Click down here to set up your appointment, or call us 250-220-8686.